Good evening to you all. Thank you for joining us in yet another session of today's training. I want to appreciate you for always taking your time to be part of this training. This is a free training provided by the Institute of Global Peace and Conflict Management to empower its followers with skills, to empower the people with skills and knowledge they need in conflict resolution. So Uh, it is a good thing that you have taken your time to participate in this training. And I'm delighted to see you joining today as well to be part of today's training. And I hope that you are going to have a wonderful time as we enjoy the class together. Um, for those of you that did not get your results in the emotional intelligence right, we'll give you 10 days or maybe 15 days to go and write your manual. We will consider you for another examination and see how you can perform. If you do not pass in the second attempt, we will ask you to go and study the whole course again when it comes the next time. So I want to appreciate you all for always taking your time. And for those of you that are also going back to go and watch the video, for those of you that missed the lesson and are going back to watch the video, you are doing the right thing. That will help you to meet up with what you did not cover in the exams. So thank you very much. We appreciate you. So today we're going to look at. My name is Ambassador Tawle Joshua, the registrar of the Institute of Global Peace and Conflict Management. So today we'll be looking at arbitration process. Arbitration process. Or if you join us, you can do way to share the meeting with someone and then invite them to also come and participate in this free training to acquire the necessary skills they need to, navigate the conflicts in their workplace environment and businesses and every walks of their life. So just invite someone to participate in this training and you'll be doing the person a lot good. All right, let's look at arbitration process. Arbitration process. Yesterday we were trying to look at our introduction to arbitration. Here we look at some certain things and we also look at the benefits, the disadvantages and advantages of arbitration. And today I want us to look at the arbitration processes or process, right? Because arbitration uh, has some stages, has some levels that you're going to carry them out. Arbitration has a procedure or steps that you're going to take to conduct a seamless words arbitration engagement. So, but one of the things that we're going to consider under arbitration process is arbitration agreement. Arbitration agreement, all right? So we'll be looking at arbitration agreement and the things that we're going to cover under this arbitration agreement. We're going to look at how you can draft an arbitration agreement, and then we'll also look at the validity of an agreement. We'll also look at the scope of the agreement. All right. So we're going to look at arbitration agreement. When we talk about arbitration agreement, what does that mean to you? All right. An arbitration agreement, we say, is a contract in which two or more parties agreed to resolve disputes outside of court through arbitration. Now, when we look at once you reach an agreement with someone that where this matter for us is don't need to go to court, we can settle it out of court, and then you agree whether the agreement can be put in written. Do you understand? and which is one of the things that we're going to look at, how to draft an arbitration agreement. You understand? So you put it in written that on so day, and you and Mr. So agree that you on this matter, property dispute, concerning that particular land, that you agree that you are going to resolve the matter out of court. Do you understand? And so it will be written and it will be documented that you and you have said that you are going to resolve your matter out of court. That is arbitration agreement. But now, how do you draft an arbitration agreement? How do you draft an arbitration agreement? Okay, because it's very important that you should draft, you put it in written what the parties are saying or what the decision of parties considering their action on a particular matter is, their standpoint. Do you understand? Document it, document it. So we are saying what when we talk about drafting an arbitration agreement, what does that mean? We are saying that in drafting an arbitration agreement, it has to, you have to consider some certain things, and they are very key components, all right, that will ensure validity and clarity. Because when you are drafting, you do not just go about drafting the agreement. There are some certain things that you must put in place. There must be legal procedures that you also have to consider. What the law says, or what are the rules? Do you understand? You have to put some of those things into perspective before you draft an agreement. So, but in drafting an agreement, one of the components that must be there is clear language. Clear what? Language. The language in the agreement should not be ambiguous. It should not contain jargons. Use clear language. Do you understand? Use straightforward language to avoid ambiguity. Do you understand? To avoid what? Ambiguity. Clearly states that the parties agree to arbitrate disputes. Do you understand? Clearly state that what the parties agreed to what arbitrate disputes. That is, they agree that they are not going to go to court. So that when the matter is resolved, they will say, no, but this is not what I wanted. I wanted Miyashi to go to court. No. Once that is written and the document is there to attest to the fact that you agree that you are going for arbitration, and now you are arbitration. So the language must be clear. Do you understand? And avoid words that are ambiguous, that can, cause confusion. And avoid it. 2, look at the scope of the dispute. Scope of dispute. Do you understand? Specify the types of dispute covered. You have to specify in the agreement the type of dispute covered. It can be contractual, torts, statutory claims. Do you understand? You can include or even exclude certain matters as needed. So those that may not be so needed to appear in the agreement, you can exclude them, but you can capture the key matters that can, describe what you are trying to talk about. So clear language, scope of dispute must be specified. Do you understand? So you have to specify what the dispute or the agreement covers. Do you understand? So you have to, is it contractual? If there was a contractual agreement and then there's a problem over the contract issue or tort issue or statutory claims that need to be met or anything like that, I mean, any of that matter, you have to consider it. Then arbitration rules. All right, you have to make reference to the rules governing the arbitration process. You have to make reference to what arbitration rules governing the arbitration. We have different legal frames that you can use, frameworks that you can use. Even in Nigeria here, we have what we call ACA. That's ACA. Stand for what? Arbitration and Conciliation Act of 1988. It's our law. Maybe many of you may not be aware of this. Do you understand? But it's there. And then we have others. American Association or Arbitration Association or Association of Arbitration or Arbitrators. Do you understand? And then we have the Judicial Arbitration mechanism or whatever system. So they are there. That is judicial arbitration and mediation systems. They are there. Do you understand? JAMS. We have the JAMS, we have the AAA, or we have the ACA. So it depends on the jurisdiction. If it's in Nigeria, you have to make reference to ACA, which is ACA, which is what Arbitration and Conciliation Act 1988. All right. So you can take your time. If you want to specialize to be an arbitrator, a specialist in arbitration, you can take your time to go and consult that act so that you know what the act says. Do you understand? It will help you to have knowledge of what the act says, and it will help you to arbitrate well when you have to arbitrate. So you have to make reference to the legal frameworks before you draft an agreement. You understand? Before you draft an agreement, you have to make reference to those acts. What does the act says? Do you understand? Because there are certain matters that may have been referenced also. Yeah, so there may be other legal proceedings that are available for you to consider before drafting arbitration agreement. Are we together? So make reference to those acts. They are very, very important. The arbitrator selection. Outline how arbitrators will be selected, including the number of arbitrators and any qualification required. So in your agreement, you also are going to state down how arbitrators will be selected, the number required, the qualification expected of each arbitrator must be stated. Do you understand? Their level of skills, their level of expertise must be stated. Do you understand? Maybe they can go ahead to even state years of experience required. Do you understand? So that you will know that this is what you are dealing with. Are we together now? I hope we are together. So now, let's look at location. Indicate where the arbitration will take place, which can affect convenience and legal jurisdictions. All right. Indicate where the arbitration will take place, which can affect convenience and legal jurisdiction. So you have to state, right, the location where arbitration will take place. State it. Is it going to be in Abuja? Going to be in Lagos? It's going to be in Enugu? It's going to be in Port Harcourt? It's going to be in Kano? Is it going to be outside of Nigeria? Then it becomes an international arbitration. Do you understand? Once it's outside of the particular country, it becomes what? An international arbitration. But we have what we call domestic arbitration, which has to do with internal issues. Do you understand? So that's it. So we have confidentiality. So include provisions regarding the confidentiality of the proceedings and any outcomes. So you have to state the level of confidentiality expected in the arbitration process. Do you understand? So you must state it in the letter, in the agreement, rather. So you have to state that for this proceeding, it must be highly confidential, and whatever that has been decided here and discussed should remain here. So what is being discussed in Vegas must remain in Vegas. You understand? But if we give room for chapter rules, house rule, then it's possible that someone can take it and make reference with it outside of the arbitration house. Then we'll talk about costs and fees. Address how costs will be handled, including the allocation of arbitrator fees and other expenses. So you have to also state what is going to be accrued to the arbitrators in terms of fees. Do you understand? How much each will earn and pay, how many hours, or is it monthly, or is it weekly, or is it hourly? It depends. You have to state it, and how much that can be, how much it can cost to fulfill that. So you have to state it in the agreement. And then finality of awards. State that the arbitrator's decision will be final and binding, and specify any limited grounds for appeal. Do you understand? So now you have to also state in the agreement that whatever decision that has been arrived upon in the course of the arbitration, then it remains final, so that parties will know that as soon as the process is concluded and all the hearings done and decision is being made, then you may have limited opportunity to appeal, not to appeal at all. Do you understand? So they should be aware, and this must be contained in the arbitration agreement. Do you understand? To avoid any form of disagreement and conflict. You understand? So when it comes to drafting arbitration agreement, these are the things that you're going to consider. All right, let me go over them again. We say that when you are drafting an arbitration agreement, you should do what? Make sure that the language is clear. You should make sure that the scope of the dispute is defined. Do you understand? And then also you should make sure that arbitration rules are being make reference. Do you understand? Make reference to arbitration rules. Don't just assume and then begin to write things in your head. So arbitration selection, arbitrator selection also must be stated. What are the guidelines to select arbitrators? What are their qualifications? All right. Then location should be determined. Are we going to go out of our own state to go and meet our arbitration, or we're going to meet in the same location, in the same city, and then meet with arbitrators? Do you understand? Confidentiality, you should state the level of confidentiality and the degree of confidentiality that is involved. You must state it in the agreement. You must also state the cost and fee that are attributed to arbitrators. Whatever that will be accrued to the arbitrators, you should be able to align them in the agreement, and then the finality of the award, stating that the decision of the arbitrators are final, and of course may have limited ground for appeal, and you can specify those grounds in case maybe there's need for appeal. Someone can approach those grounds and then appeal. Otherwise, you state clearly that there's no room for appeal. You understand? Because we told you that in agreement, in arbitration, there's limited chances of appealing. Do you understand? So that's what I mean. So when it comes to the component of arbitration process that has to do with written arbitration agreement, these are the things that you're going to consider. And then, so we're going to look at another component of arbitration process, which is validity of an arbitration agreement, right? Validity of what? An arbitration agreement. Validity. Validity of an arbitration agreement. So we'll look at the legality, all right? You're going to look at the legal aspect of it, the legality of the arbitration agreement, right? So the agreement must comply with applicable laws. In the US or in Nigeria, for instance, we have the ACA. In US, we have what we call the Federal Arbitration Act. Whereas in Nigeria, we have the Nigeria Arbitration and Conciliation Act. Do you understand? ACA. So this provides a strong legal framework supporting arbitration agreements. Do you understand? So this is what it means. So you are operating in Nigeria, you are operating in America, and you want to make reference to any of this, consider the validity of the arbitration agreement, then you have to consult this act to help you and to guide you on how you go about addressing the issue. Then mutual assent. Mutual assent. Both parties must voluntarily agree to the terms, evidenced by signatures or other forms of acceptance. Either you, if you don't know how to sign, you can thumb, all right? You can thumb, show that you endorse, all right? Or if you can sign, you sign your signature, mutual assent. Do you understand? You have to assent to the agreement that yes, you are party to this agreement. Do you understand? You are party to this agreement. So that is why you must assent it. Then considerations. There should be consideration, something of value exchange to support the agreement. Do you understand? Yes. What are those uh, things that we're going to consider? Time, money, whatever that will support the agreement must be put there as something of value. Do you understand? Something of value, right? So capacity. Parties must have the legal capacity to enter into the agreement. Age, mental competence. Do you understand? So all of this must be considered. Is it underage? Is it a minor? You must take note of all of those things. Or he has colon mentality issue, or is the person sound or not sound, deaf, or any form of disabilities that may hinder the person's ability to comprehend what is being said. So you have to consider all of those factors. Do you understand? Before endorsing any agreement or signing or sending to any agreement. So any agreement that you sign that contravene any form of legality regarding someone's age, health status, it may consider as null and void. You understand? It may consider as a manipulation. You understand? So that's why you should take care of all of these things so that you not go and enter into agreement with a minor and then you expect that if it must be, if it's a minor, the minor must have a representative that is sound, well, well sound and you know that are well competent to know what's going on. You understand? So when it comes to validity, the validity of an arbitration agreement, these are the things that you're going to consider: the legality, the mutual assent consideration, and the capacity of the parties involved in the arbitration process. They must be considered. So let's look at the scope. Another component when it comes to arbitration agreement that you have to look into is the scope of an arbitration agreement. All right. So let's look at the broad and narrow scope. Broad and narrow scope. All right. The broad scope covers all disputes arising out of or relating to the agreement commonly used. Do you understand? So this is commonly used because it comes out of the disputes covered. All right. Then we have the narrow scope. It limits arbitration to specific types of disputes, such which may be preferable in certain situations. All right. So you can narrow it down maybe based on jurisdictions and other limitations. You can start to use the narrow scope of the arbitration agreement. Otherwise, you can use the broad scope, which is generally and commonly used. Do you understand? Then we look at the exclusions. So clearly state any exclusion that is dispute related to intellectual property rights to avoid confusion about what is arbitrable. Do you understand? So you have to consider all of that. So what needs to be excluded should be excluded. Now, what must be included. So, but you have to take note of all of those things so that you will not, so that you know what is going on, so that you not just go and put anything in the document. So, We talk about enforceability. Enforceability. Courts generally favor arbitration agreements, all right? But the scope must be clear to ensure enforceability. That's why we say you should be mindful of what you are including and also what you are excluding. Do you understand? So don't include something that will be hinder the enforceability of the award. Do you understand? So ambiguities may lead to what disputes over whether a particular issue is subject to arbitration. So that is ambiguities may bring argument. You know, in court, they argue over technicalities. They can even argue over a particular word. You can use one word and give it interpretation, and then it becomes confusion. Do you understand? So you have to be mindful of all of these things. So when it comes to the scope of an arbitration agreement, these are the things that you're going to consider: the broad versus the narrow, exclusions, enforceability. You must consider this aspect so that you will not go and put something in the agreement that may affect its enforceability. Do you understand? So an effective arbitration agreement should be well drafted, addressing all essential elements to enhance its validity and enforceability. It is also advisable to consult legal counsel, right, when drafting to ensure compliance with applicable laws and to meet the specific needs of the parties involved. So this is what you need to do when it comes to drafting an arbitration agreement. Do you understand? You must consider what? So maybe you can mention those three components we have discussed. Drafting an arbitration agreement, and then you should also consider what? The validity of an agreement, and then you consider what? The scope of an arbitration agreement. These are key, and they are very, very paramount when it comes to arbitration. Are we together? Are we following? So, if we are following, do way to share it with someone. Let them also be part of this training. Right? Share it with someone. Invite someone to be part of this training. You can like, you can comment, and paraphrase what you are learning, what you can hear. All right? So, so that they can also know what's happening here. So that I also know that you are following us. It's not just being connecting and staying there. So share it with someone, invite them to be part of this today's training. All right. So let's look at selection of arbitrators. Let's look at what selection of arbitrators. Selection of arbitrators. The selection of arbitrators is a crucial aspect of the arbitration process. All right. As the arbitrator expertise, impartiality, and decision-making skills can significantly impact the outcomes of a dispute. So when you want to select an arbitrator, there are key and critical things that you must consider: the arbitrator's experience, the arbitrator's ability to remain impartial, and then also the arbitrator's ability to make sound and well-informed decisions. Do you understand? So it's very, very important so that you not go and just pick someone somewhere to come and arbitrate. Do you understand? You must consider the person's level of expertise before the person can become your arbitrator. Do you understand? So when it comes to selection of arbitrators, let's look at the qualification and expertise, right? So we have several factors that we're going to consider, key consideration that you must put in place when you want to select your arbitrators. One is qualification and expertise. Qualification and what? Expertise. So relevant experience is important. Relevant what experience? Does the arbitrator have experience in the area of dispute? If not, don't go and just carry somebody anywhere. If somebody who doesn't have knowledge in what property law says, and then you go and carry the person, it may spoil your show. Do you understand? So that's why you should amaze yourself with all those uh, what do you call it, Arbitration and Conciliation Act laws. You have to amaze yourself with it. And then so choose arbitrators with expertise in the specific industry or legal issues relevant to the dispute. Do you understand? Relevant to the dispute. You not just go and choose somebody because he sound, he has not lost a case, he has been arbitrating where has he arbitrated in the area of your dispute? If no, then look for someone that has experience in your area of dispute. Do you understand? Professional background. Consider their professional credentials such as legal education, relevant certifications, and experience in arbitration. They are very, very important. So, like this certificate now can give you a background to start arbitration. You understand? You can even be a consultant. So that's what it means. So you can be a consultant. You understand? So arbitration is very, very key. And then parties must be given opportunity to be able to arbitrate well. So, but they must have experience, they must have the knowledge, they must have the skills needed for them to arbitrate. So, impartiality and independence. Impartiality and what? Independence. So, it's also another factor that you must consider when you are selecting your arbitrators. Impartiality and what? Independence. So, conflict of interest, right? Ensure arbitrators have no conflict of interest with the parties involved. That is, they are so independent. Whatever is happening here, they have no interest, they have no concerns whatsoever. This includes financial ties, personal relationships, or prior involvement in the matter. You know, so we have to avoid disclosure. Administrators should disclose any potential conflict or relevant relationship before being appointed. Do you have any form of relationship with a person or any of the parties? Disclose it before you being appointed. If they come for you, tell them, sir, but that's my friend. So we have been friends for so number of years. Do you understand? So that they will know that this is what is involved, whether they can take that risk or not. The number of arbitrators. Another consideration you should look at is the number of arbitrators. So, is there a single or is there a single arbitrator or a panel? Are you going to invite a panel to look into the matter, or is just one person to look into the matter? Do you understand? So, decide whether to appoint a single arbitrator or a panel. Typically, three. Typically, what three? A panel can provide diverse perspective, but may also increase complexity and cost. That's the disadvantages. You understand? Complexity. That is able to bring argument and bring their opinion, perspective. At the end of the day, they're arguing so that you can pay them. You understand? Something that they don't need to argue. They'll say argue so that they can also receive their own fee. You understand? So these are the things. So you have to consider all of these factors. And then we talk about selection process. Selection process agreements by parties. So the arbitration agreement may align the selection process. If not, parties can agree on a method such as mutual selection, list from an arbitration institution. Do you understand? They can try to get some members of an institution, say like the institute, that are way grounded in the area of arbitration to come and arbitrate. Do you understand? So that's what it means. Or they may decide to go and pick from the legal professions and bring them to come and arbitrate. So depends. Do you understand? So institutional rules, all right? If using an arbitration institution like like RGPCM, like ECA, like whatever, follow their rules for appointing arbitrators, which often include list of qualified candidates. Like if you want to use RGPCM now, RGPCM will now select some people that RGPCM feel that they have the necessary qualification to arbitrate and give it to you. Do you understand? So that you can use, so that they can help in arbitrating on your matter. Do you understand me? So, geographical consideration. Geographical what consideration? Consider the location of the arbitrators. especially in international disputes. Proximity can affect logistical aspect and the arbitrator's familiarity with local laws. All right. So it's very, very important. So you have to, the geographical consideration is also a key factor and must be considered. Diversity and representation. Diversity and what? Representation. So diverse perspectives. Aim for a diverse panel to reflect their different viewpoints, enhancing the fairness and inclusivity of the process. But we told you that this can also compound issues and also, increase the cost. But it's good that if you can be able to afford it, three arbitrators form a panel and discuss the matter, bringing different perspective to the issue, and then giving you more insight in the issue and what's involved. So I think it will be better if you can have a panel. Do you understand? So that their collective inputs will help you to get a better result at the end of the day. So availability and commitment. So time commitment. Ensure that the selected arbitrators can commit the necessary time to hear the case and render a decision in a timely manner. Do you understand? So once you made a list of those that have been selected, you must commit to the fact that you'll be available. You'll be available whenever your attention is needed. Do you understand? So that's what it means. Review of arbitrators profile. So once you appoint the arbitrator, you have to review their profile. So far as if we send someone approaches us demanding for arbitrators, and we send a list, and then we send you their profile. Do you understand? So they can review. Are these people qualified? Do they have experience in the field? Do they have certain qualification? And what knowledge they have to arbitrate? And how many years they have been doing arbitration? All of these things will be considered. Do you understand? So these are very, very important aspects when it comes to selecting arbitrators. But I want us to go down to look at, go deep into when it comes to qualifications, appointment, and the challenges of selecting arbitrators. All right. So let's look deep into arbitrators' qualifications. Do you understand? So first and foremost, we say that when it comes to qualifications of arbitrators, you must look at their legal expertise. All right. Does he have a legal experience? You understand? So it's very important. Arbitrators should have a strong understanding of the law. Understanding of the law. I'm not saying that you must be a lawyer, but you must have a strong understanding of what the law says. You understand? So far as applicable to the issue on ground. So this may include specialized knowledge in areas such as commercial law, construction law, or intellectual property laws. You must have certain level of knowledge. You must command certain level of authority in terms of knowledge and experience and expertise in those areas before you can be assigned to arbitrate. Do you understand? It's very important. You must, um, conversant with what the law says. Industry knowledge. How can you go and bring somebody from banking sector to come and arbitrate for somebody who is in manufacturing industry? Do you understand? It doesn't work like that. So experience in the relevant industry can be crucial. All right. So especially in complex cases, arbitrators familiar with industry practices and standards can better understand the nuisance of what the dispute. So you have to demonstrate industrial capabilities for you to be able to be nominated to participate in a particular arbitration proceedings. Do you understand? You must command some level of authority in terms of knowledge, industrial related knowledge before you can consider arbitration experience. So prior experience as an arbitrator is important. Have you been practicing? For how long have you been practicing? You understand? It's a question and it must be answered. So experienced arbitrators are often more adept, all right, at managing proceedings and making informed decisions. So those that have been practicing for years can be able to make informed decisions and make choices that can fit and benefit the parties in conflicts the more. So we'll talk about impartiality. That's when you're talking about qualification of an arbitrator. This arbitrator must be impartial and must have integrity. Do you understand? Arbitrators must demonstrate independence and impartiality. They should have no conflict of interest that would affect their judgment. So you must choose those that are honest, those that are not partial at all. Do you understand? That can maintain neutrality no matter what happens. And the reason why we're emphasizing integrity here and honesty is because there's possibility that you may be bribed to make certain informed, certain decision, and then you say, no, I don't take bribe. Do you understand? I will not accept bribe because it's against my profession. My profession. Do you understand? It's against my practice. So, so that's why you need people of characters. Even in an environment where character is so decayed now, can still get people that are good and can say no. I don't take bribe. Do you understand? When you take bribe, I'll walk away. Do you understand that kind of implication? So communication skills, effective arbitrators process. Effective arbitrators possess what strong communication and negotiation skills, what that can communicate and communicate effectively. Do you understand? Which are essential for conducting hearings and facilitating discussion between parties. So you must have reasonable amount of skills when it comes to communication skills to be able to do well in an arbitration. So these are the qualifications that you must see in an arbitrator before you select him or her. Do you understand? Those qualifications are essential to help you to be confident in the process because of the people you selected. Do you understand? So that's why it's very important that you should be involved and know who that you are selecting to arbitrate. Very important. Then let's talk about appointment of arbitrators. Appointment of arbitrators, right? Appointment of arbitrators. Let's talk about the appointment of arbitrators. When you want to appoint arbitrators, what are the things that you're going to consider? Arbitration agreement. The arbitration agreement may specify how arbitrators are to be appointed, including the number of arbitrators and the selection process. That's what we have discussed before. Do you understand? So, in appointing arbitrators, you determine how many of them you need. All right, depending on the area of dispute and what qualification. And if the dispute is such a way that it has um, other aspects connecting it, you have to look for arbitrators that have experience in those aspects that connect the dispute. Do you understand? Very important. So talk about mutual agreement. Mutual agreement. In many cases, parties mutually agree on the selection of arbitrators. This can be done directly or through a list provided by an institution. All right. So if they have someone they know that they can just use, but if they don't have, they may decide to, you know, based on the list provided to them by an institution. Do you understand? And then they select from it and they engage them. Then we have institutional rules. If arbitration is governed by an institution, for instance, ACA, the institution rules usually outlines the appointment procedure, how arbitrators should be appointed. So you should follow the procedures outlined by uh, Arbitration and Conciliation Act of Nigeria. It will help you. So this often involves submitting a list of potential arbitrators from which parties can choose. You understand? So if a party approaches concerning arbitrators, we can decide to provide a list of our members who are specialists in this area for them to go and mediate. Do you understand? So that's what it means. So our members can mediate Most especially those that have knowledge in those areas, we can select them, send to the parties, and parties will select. And I know one of our members who is practicing arbitration very well. I think it's one of is practicing on behalf of some institution. He's from Edo State. I know him very well. You understand? So he is capable and he knows what he's doing. So that's it. So and sometimes you see him, you mistake him to be a barrister, but he's not. He's just an arbitrator. But he's very sound and vast in so many areas. Do you understand? So court involvement. In scenarios where parties cannot agree, court may intervene to appoint arbitrators, especially in domestic arbitration contexts. Yeah, it may be difficult to intervene like that in the international arbitration, except maybe it's that you use the international court of justice or international uh, court of justice for such, or international court for such kind of consideration. Otherwise, it will be very, very, very difficult. Then let's look at the challenges to arbitrators. What are the challenges that confront arbitrators? Challenges regarding appointment of arbitrators. One of them can be challenges for bias or impartiality, because they are human and they may tend to bend towards someone, then be biased based on the process. The process sometimes can, have what we call collateral damages, maybe based on certain actions. Person, somebody that was not supposed to be shown interest for any reason, but maybe in the course of process that that the person maybe discovered that someone is being arrogant and all of that, then his emotion will begin to, you know, affect the process, and he himself will begin to take side. You understand? Whether what you covered is still going to be the same thing. So lack of qualification. All right. Another challenge is for you to make an error to point an arbitrator who doesn't have qualification or knowledge in the area concerned. Do you understand? So that's why you must not just go and pick anybody anywhere to come and arbitrate. You must know the person and know their qualification. And if you do not know the person but know their qualification, know their CV, read their CVs, read their resumes, know what they carry. Do you understand? So that's what it means. So procedural issues. Another challenge that arbitrators or choosing arbitrators or selection of arbitrators may come to play is what um, procedural issues, procedures, all right, may be a procedural matter. So challenges can arise from procedural irregularities in the appointment process, such as failure to follow agreed upon procedures or institutional rules, right? It may affect. And then we'll talk about grounds for removal, all right? Most arbitration frameworks allow parties to seek the removal of an arbitrator on specific grounds such as incapacity, misconduct, or failure to perform their duties. So if you discover that uh, a particular arbitrator is becoming impartial, misconduct, or is not having the ability to perform as expected, you can request for the removal of such an arbitrator. Do you understand? You have such grounds, right? So they will help you to request for change of arbitrator. Are we together? Are we still following? Let me know that you're following me. And also let me know that you have shared this meeting with someone. Try and share the meeting with someone. Let them also be proud of what we are doing here. This training is free. So you to be generous in sharing the links with people for them to come and study with us. It's for free. I'm encouraging you because this is the only way you also can. This, in fact, through this medium of sharing with people, what you are doing is that you are also promoting peace. If you can help us to get to many people, it means that you are helping our society to be better. Because if they come and they receive training and they are transformed, don't you think you have contributed? That's why we're insisting that you should share. It's not anything. We are insisting that you should share, because once they see it and they come and they receive the training, then there's possibility that our society will be better. So you can see your own contribution. All right, you help to attract someone, and we train, and then we release the person to the society, back to the society, and the person come back as a transformed person. Ideas, mentalities change, knowledge acquired, skills acquired, and then the person begins to, unlearn some of the things. Do you understand? That he or she did not know, begin to unlearn, and then begin to make our society better. Somebody that believe in violence, maybe after this class, the person will drop the aspect of violence completely, has been transformed. Do you understand? So what you are doing is, when we say share, is that you attract someone, the person will come, you play your own part, we will train. Do you understand? And then it's a kind of a refined process. Yes, a transformation, or it's a kind of rehabilitation. We rehab the person and then send the person back into the society better, informed, equipped, and ready to promote peace in his or her community. So that's what we're saying we should share. So please, whenever you join the meeting, don't wait for anybody to encourage you before you can share. Just go ahead and share and invite someone to take part in the meeting. You understand? Thank you very much. So let's look at the last thing for today. We are going to look at conduct of arbitration hearings. Conduct of what? Arbitration hearing. All right. So how do you conduct the arbitration hearing? How do you conduct arbitration hearing? The conduct of an arbitration hearing is a structured process that facilitates the resolution of disputes outside of traditional court settings. Do you understand? That's what it means. So when the hearing takes place but outside of court, all right? So what are those components that are involved in conducting arbitration hearing? One, we talk about the pre-hearing preparations. Pre-hearing what preparation? What are you going to do here? You have what we call a pre-hearing conference. Do you understand? Often a pre-hearing conference is held to discuss procedural matters. Procedural matters. Do you understand? What you are discussing is not the case, but you are discussing the procedures to be involved in the process. Do you understand? You set the timetable and then clarify issues. These are the things. You set timetables, clarify the issues. Do you understand? So, um, like when before the training started, we had a meeting. We said these are the conditions, these are the rules, and this is what we expected you to do. Do you understand? So you are going to have, when it comes to arbitration, you're going to have what we call a pre-hearing, and these are some of the things. The timetable, you explain some of those things. Our lecture holds every day except Wednesday. Do you understand? And if there are any issues, they will clarify it. This can help streamline the hearing process. Do you understand? Then we'll talk about submission of documents. Submission of documents. Parties typically submit their written statements, evidence, and witness list in advance. You understand? So this allows the arbitrators to review the materials before the hearing. So during, maybe it can be done during pre-hearing conference, where parties may submit uh, the relevant document, make relevant statements, and also bring a list of witnesses, and I can witness whatever that is happening there. Do you understand? Very important. Then we'll talk about arbitration rules. So familiarity with applicable arbitration rules, like we have said, the ACA, the AAA, the JAMS, is crucial as they outline procedural and expectation for the hearing. All right, they outline what procedures and expectation for the hearing. These are the procedures, and this is what we are expecting to achieve at the end of the day. So it has to outline it. Do you understand? Then we'll talk about opening statement. Opening statement. Opening statement. Introduction. The hearing usually begins with the arbitrators introducing themselves and explaining the proceeding. Yeah, my name is uh, Mr. Basusu. I'm an arbitrator. I've been practicing for 20 years now, and I have qualification in so. I have also a professional diploma uh, in in alternative dispute resolution with the Institute of Global Peace and Conflict Management. I have, which is accredited by the American Council of Training and Development. So you mentioned all of that, and you know, rest yourself. Do you understand? So that, and then after that, also talk about the proceedings, what is involved. Do you understand? We explain all of that. So, opening statement. Opening statement. Now, each party should present an opening statement outlining their position, key argument, and the relief sought. Do you understand? If you are asking for an award, you should tell us what you are asking for. So all of this I know. So this set the stage for the evidence presentation. You understand? So once you make your argument, then and everybody makes submit and make an argument, at the end of the day, it's make create room for evidence. Do you understand? So talk about closing statement, closing statement. Summarization is key here. After all evidence have been presented, each party provides a closing statement summarizing their case, reinforcing key arguments and addressing any weaknesses in the opposing party's case. Do you understand? So you must uh, give a summarizing statement. At the end of the day, for us, this is what we are looking at. This is what we're looking at. So we're looking at. Very important. Then we talk about post hearing submission. Post what? Hearing submission. Post hearing submission. Written summaries. Written what summaries? All right. In some cases, parties may be asked to submit written summaries of their argument or additional evidence after the hearing. This can help arbitrators in their deliberations. So, even after a case must be heard and examined, you can still submit evidence if you think the evidence is strong enough to support whatever argument you have offered. Do you understand? So it's important. Deliberation and award. So deliberation after the hearing, the arbitrators will deliberate privately to discuss the evidence and argument presented. So then after they are satisfied with whatever argument, they will pronounce an award. Do you understand? Issuance of award. The arbitrators will issue a written award detailing their decisions, reasoning, and any orders. Okay, based on this fact, based on whatever they say, and based on this the decision of the arbitrator. So this award is typically binding, meaning it can be enforced in a court of law. Do you understand? It can be enforced in a court of law. Then let's look at the issue of confidentiality. Private proceedings, right? Arbitration hearings are generally private and the details are not publicly disclosed, contributing to confidentiality, except where there are issues of life threats that you can decide to review. Otherwise, it is totally a secret procedure, private procedure. You understand? So that's what it means. So, but let's talk more on some of these aspects that we have discussed here. We'll be looking at the presentation of evidence, how evidence are being presented. We'll look at the examination of witnesses, and then we'll look at the submission of arguments. Do you understand? So I want us to look deep into some of these aspects of arbitration before we call it a day. So evidence presentation. So what kind of evidence are you bringing? So types of evidence must be considered. Parties can present various forms of evidence, all right, including documents, expert reports, and physical evidence. So whatever evidence that is at your disposal to be able to share, you can share them. Do you understand? You can share them, and then you can be able to submit it as an evidence to consider. Then submission of evidence. So evidence is typically submitted in advance. You are not going to submit in the process. That is during the pre-conference or pre-hearing conference. That is when you are expected to submit your evidence. Do you understand? In advance before the proceedings start. So advance of the hearing, often in the form of witness statement or expert reports. This allows the tribunal to familiarize itself with the materials beforehand. You understand? So rules of evidence. Unlike court proceedings, arbitration often follows more flexible rules regarding the admissibility of evidence. So allowing for a broader range of materials to be considered. So as many materials that are at your disposal that you want to share as evidence to support your argument, you are allowed to bring them. Do you understand? You're allowed to bring them. So that's about the presentation of evidence. So what do we say? We say that the types of evidence matters, the submission of the evidence and the rules of the evidence matters. Then let's look at the witness examination. Witness examination. We'll talk about direct examination. The party who calls the witness conducts the direct examination, allowing the witness to present their testimony and evidence. Do you understand? So that's what we call direct what examination. So the party who called the witness conduct a direct examination, so allowing the witness to present their testimony and evidence. So that's what it means. And then we'll talk about cross-examination. Cross-examination, the opposing party has the opportunity to cross-examine the witness. Do you understand? Challenging their credibility and the facts presented. So if you examine someone may try to oppose and also criticize your argument and your decision and the evidence presented, just like in the court. Cross-examination, do you understand? Then you have what we call re-examination, direct examination, cross-examination, re-examination. Take note of this. If I ask you in the exam, you will not be confused. All right? So re-examination. After cross-examination, the original party may conduct a re-examination to clarify any point or address issues raised during cross-examination. So person who open the conversation through direct examination can, have the opportunity to re-examine the person or the issue. Then the last thing that we're going to consider here now is the submissions. All right. So opening statements. Each party typically present an opening statement outlining their case, the evidence they will present, and the desired outcomes. So you are telling the arbitrators what you are expecting at the end of the process in your opening statement. All right. Talk about closing argument. So after the evidence has been presented and witnesses have been examined, parties make closing arguments, summarizing their position and the evidence. All right. So at the end of the day, this is what we say, and this is our evidence. All right. So this is our evidence to support our argument. Do you understand? So these are the issue. All right. Mhm. So written submissions. In some cases, parties may also provide written submissions to the tribunal, either during or after the hearing, to reinforce their argument. So in case there's a need for you to put it in written, you go ahead and do it. Let's look at some additional consideration when it comes to submissions or into comes to this issue of arbitration. Talk about confidentiality. Arbitration hearings are generally private, and the confidentiality of the proceeding and evidence is usually emphasized. Tribunal's role. The arbitrators have the authority to manage the proceedings, including the admission of evidence and the conduct of examinations. So they may ask questions and seek clarification during witness testimonies. Do you understand? So this is what this is the job of the this is what the role of tribunal is. But I'm telling you that arbitrator has the power to admit and cross-examine uh, evidence. Do you understand? Procedural rules. The specific procedures for hearings can vary based on what the arbitration rules choosing. It can be ICC, it can be LCIA, that's London Court uh, of International Arbitration. We talk about the UN, the UCITRA, that is the United Nations Commissions on what international trade trade law, okay, and any other agreements made by the parties can be considered. Do you understand? So this is what we cover in this course today. Tomorrow we are going to look at the arbitration rules and procedures. So we are considering AA, ICC, UCITRA. We can also consider maybe ACA, for instance. Now that is ACA. Do you understand? So just make yourself available so that you know what the act says. Do you understand? Which will help you to get more knowledge. All right. So, and before we finish this module, we'll be looking at the international arbitration. All right. The role of international institution in arbitration. That is, we're looking at ICC. Do you understand? Very important. Then we'll look at recognition and enforcement of international arbitration awards. So make your time not to miss any of these modules, these units that are remaining for this module. So thank you very much. We appreciate you and your participation. All right. So we are going to meet on Thursday. We will not be having training tomorrow, but this training will be rebroadcast by tomorrow evening. So if you miss it or want to listen to it again, you listen to it by tomorrow evening. All right. But tomorrow we're not going to have a live training like this, and we'll have it on Thursday, Friday, Saturday, and Sunday. So make time to be available for this training. Thank you very much. We appreciate you. We appreciate your participation in today's training. Any question? Somebody saying questions. What is the question? In Ethan, what is the question? You say you have a question. I thought you have a question. I'm trying to look at the question. If you have a question, just go ahead and ask straight. Don't say question. If you say question, you're wasting time. Just ask your question and then we'll attend to it. Right? So I didn't see your question anyway, but if I see it, I will address the question. So those of you that did not pass your examination, the emotional intelligence examination, you have 10 days or 10 to 15 days to go and read your book again, listen to the videos, and watch them again. So we'll have another examination for you Uh, we will announce the date, but just start reading. I will post it in our group on emotional intelligence so that we can get the details. But by all means, try and be part of. Just try and read. If you did not pass your emotional intelligence exam, just go and read your books again. Listen to the videos again. We will conduct a second exam for you, and let's see how you perform in that examination. So thank you very much. See you on Thursday. Have a wonderful night rest.